But let's take you to this now. Privacy provisions have delayed the release of the Sexual Offenders Register. The delay is making public the National Register for Sexual Offenders have been attributed to strict confidentiality provisions under the Sexual Offences and Related Matters Act. The register was meant to be released on the 28th of February, but for more information on just, we're joined by Alison Tilley, who is a panel member for the Information Regulator. Alison, good evening. Thank you so much for your time. Really do appreciate it. Let's talk about what the Criminal Procedures Act says specifically in relation to sexual offenders. It is clear information about sexual offences may not be publicized insofar as it may be able to identify the victims, particularly where those victims are children. But there's no clear link between the publication of offenders versus the ability to identify the victims. Or is there? Is there a controversy to be considered around the personal information requirements that are at play here?
Well, I think let's maybe take a step back and look at the National Register and what the purpose is of the register. So the idea is that particularly if you involved in a business where there are vulnerable people, let's say children, for example, you run a school. Now, you want to be able to check whether or not the people who are your employees have been found guilty of a sex offence. And the way you do that is that you go and talk to the registrar of the register of sex offenders, and you are then able to find out whether your potential employee or your current employee has in fact got a record. Now, the concern is really making that information available generally. So what the register does in the legislation that sets up the register is says that you can only access that information if you have a particular interest. So you have to be in a position where you need that information. So I can't just, call up the registrar and go, listen, I'm interested in the whether Joe Bloggs has a criminal record, would you tell me? So the question is then, well, should we do it that way? Or should we take the view that you should be able to find out if somebody does have such a record, because you may just be a generally interested person, you may live in the same neighborhood, it may be a situation where perhaps your kids go to the same school. So is there then an argument for saying, well, people generally should have access to this information? And that's really where the minister was going on this and saying, well, perhaps we should think about releasing this information more broadly. And I think where we've ended up on that is recognizing that the legislation as it stands does prevent that. So the minister was not able to make that information available because of the legislation itself. There is obviously also...
Just for clarity on that, Alison, is the legislature as written prohibitive of the action, or is it not clear on the action being permissible per se?
No, you may not. The registrar may not disclose.
Okay. So then what needs to happen? A legislative amendment to the Act as it stands, or should a separate provision be made to enable this?
The legislation itself would have to be amended, and that's something Parliament would have to do.
That's an arduously long process. Lawmaking is not an overnight exercise, and it's often incredibly laborious. What happens then in the interim?
The situation remains the same. The legislation has not been amended. Until it is amended, the register will remain only available to people who have a reason to access it.
The Act makes it clear that there must be a public interest, or the persons seeking to access the register must have a genuine public interest in order to do so. Now, if I want to determine whether or not my child goes to a school where the parents of any of the other children in the school are sexual offenders, that seems to qualify as a public interest. I may well call up the registrar and try and access that information. And if we expand what it means for something and information to be in the public interest, we can reasonably conceive of a situation where the registrar would become inundated with requests for this information. And so, as a practical consideration, making it a publicly accessible database means that we still cater to the public interest, because public interest in this instance is very broadly. Surely that might be a consideration to get around the prohibitive wording of the legislature as it stands.
No, I think the understanding at this point, and I think the legislation is pretty clear on this, is that you can't just be an interested bystander to access the record. So we're in a situation where, absent that type of relationship, that type of interest, the registrar is not going to be able to make that record available. If we want to change that, and we may well, then there does need to be a legislative amendment. Remember, this is the Minister of Justice and the Justice Ministry would be in charge of making the amendment. There are things called Judicial Matters Amendment Bills, which come through every year. This type of amendment might possibly be made by that. So it's not necessarily the normal 3 to 5 year, lead time on legislation. It probably could be done quicker.
Yeah. Alison, thank you so much for your time. Really do appreciate it. Alison Tilley is a member of the Information Regulator.